they are not so fortunate. Understanding what your auto insurance coverage will and will not provide in the way of medical care is something that should concern all of us. If you have not yet received correspondence from your insurance carrier asking you to select the level of coverage you wish to have for your next policy renewal, you will be receiving that soon. To help you understand better what the new law does and does not provide and what these different options might mean to you and your family, we have Steve Sinas with us today. Steve is a partner at the Sinas Dramis Law Firm in Lansing, a firm noted for its work representing victims in auto injury cases, including my own case. Steve not only practices in this area of law, he's also an adjunct professor at MSU College of Law, where he teaches about Michigan no-fault. Notably, Steve also serves as counsel to CPAN, the Coalition for Protecting Auto No-Fault, and as a board member for Michigan Brain Injury Provider Council. With that, please join me in welcoming Steve Sinas.
Thank you so much for that nice introduction, Anna. It's a pleasure to be with you all today. I thank you for taking times out of your day to be here and to educate yourself. Anna set the perfect context for what this is really all about. It's about human beings who are unfortunately and tragically injured when they're in an automobile, and you think an automobile is something that is just an accepted part of our life. But if you really think about it, it's this unique situation we put our bodies in where we travel at high rates of speed around other enormous metal objects that are going at high rates of speed. And when collisions take place, the injuries to the body can be so catastrophic, and the care needs that people need can be so extensive that under at least the way America has its healthcare system, there typically isn't the type of coverage people need through other forms of insurance, whether it be private health insurance, Medicaid, or Medicare. And so while people may have a view of auto accident injury cases as being something that you see a lot of on TV about lawyers having ads, and maybe some people think that there are some people out there who are manipulating the system. But the system, as far as I can tell, representing catastrophically injured people, is one that provides or has provided a huge safety net in the sea of American healthcare for all these people who are unexpectedly and suddenly injured, and the course of their life has changed, and therefore the course of their family's life has changed, because everybody has to deal with the fallout of a catastrophic injury. And I can tell you that I've just seen so much good the no-fault system has done for seriously injured people. I certainly recognize there are issues with it and tried to advocate as best as I could to improve the system without, as we say, throwing the baby out with the bathwater. Getting into the presentation today, I hope that this presentation will firmly establish the general principles of the law as we currently have it under these reforms. And there are a lot of details to talk about under, in terms of what this law covers, and there's so many different aspects to it that we could talk about today. But my focus here today is giving a presentation that allows you to understand what our system was and what these reforms have now done in terms of changing it for us as consumers. Like I said, there are lots of different aspects of the law that affect medical providers in certain ways, that affect lawyers in certain ways, that have other technical aspects to them. That's not my focus here today. My focus is to give you the principles as they apply to people who are injured in the crash, and as they apply to us as consumers when we buy insurance going forward. So with that being said, I'm going to share my screen here. I'm going to try to keep my eye on questions as they come up. If I can just have a clarification about how much time I have from now going forward, that would be appreciated. Excuse me here. All right. And Anna, how much time do I have from now? I'm sorry if I didn't see it in the chat.
You have about 40 minutes, 45 minutes.
Okay, great. Well, I certainly will try my best to leave time for questions. I want to address questions after I present this information to certainly answer questions and to make sure that all this makes sense to you all. So understanding the realities of no-fault reform. So in order to understand what's going on here now, you have to understand what happened. Excuse me. Oh, no. Excuse me here. I'm so sorry. I'm just going to talk. I know what the problem is here. Let me just fix that while I talk. In order to understand what's going on here, you have to understand what happened with regard to the original no-fault law. And in the original no-fault law, what you had was it replacing a system known as tort law. And I'm going to go back to my screen share here. Excuse me. So auto injury claims in 1973, Michigan decided that auto injury claims were no longer governed by tort law. They were governed by, they were going to be governed by the no-fault law, and that was enacted in 1973. So you say, wait, what's tort law? And you need to understand what tort law is in order to understand this system. Geez, I'm really sorry, folks. There's something going on here with my PowerPoint. I will rectify this really quickly here. Okay. I might have to go back. I don't know why it's advancing like that. So, but in any event, I think this is the problem. I had changed some things with the slideshow, and there's a setting on my computer, and I imported it into my new computer. I was working on my work computer, and I'm sorry, I just have to go ahead and make this change here. But we will be rocking and rolling very soon here.
While Steve's doing that, I would just like to remind folks that at the very end, we'd like you to stick around, is we have one question survey as to what time is most convenient for these meetings to meet. I also realized that I didn't introduce myself at the beginning, and I'm Dorothy Engelman, Vice President of Programming for the League of Women Voters. So just give me a heads up when you're ready to take it back over, Steve.
I think I'm ready, and I greatly apologize.
Okay, very good.
Thank you for your
patience. I'll turn it back
okay.
over to Steve, and
all right.
Please feel free to ask questions along the way, and I'll keep track of those. So thank you,
okay.
And here you go, Steve.
All right, I'm sorry. It was a conglomeration of these two slideshows, and I just didn't understand this one setting on my computer that would be triggered. So in any event, so we had tort law, and it's the general concept that when an injured person is hurt by the negligence of another person, they can sue that person for all of their damages. And that includes their economic damages, their lost wages, their medical expenses, even claims for household services that they now have to hire other people to do because of their injuries. And they could also sue the at-fault driver for pain and suffering damages, which are non-economic damages. So all damages are recoverable against at-fault drivers. At-fault drivers cannot recover anything. And also those who are injured in such a way that doesn't involve another at-fault driver don't have a recourse. So the snow cases, the black ice cases, the getting in a crash with a deer, you can't sue anybody in those situations. So in those situations, there was no one to sue. And there are problems with tort law. The medical expense coverage in terms of pursuing your medical expenses from the at-fault party depends on a finding of fault. You had to go litigate that. It was inefficient as you litigated the fault to figure out how your bills were going to be paid. And essentially, back in the 60s, the auto injuries were really burdening the Michigan healthcare economy, and they had to find a better way to make sure that people who were seriously injured on our roadways had coverage. And so they had this compromise, and they said, okay, we're going to take these rights that people have in tort law, and we're going to bifurcate them. We are going to take rights that people had in in tort law to recover medical expenses and lost wages and a certain amount of household services, and we're going to change those into no fault rights. And then there are going to be certain limited rights that remain to pursue against the at-fault driver. And I'll cover what those limited rights are. They're basically pain and suffering damages and income loss that's not covered by no fault. But to understand no fault a little better, I want to first start here and just talking about the reforms. That the no-fault reforms did not repeal the original Michigan no-fault law. So the Michigan no-fault law remains in effect, but the reforms greatly modified the law. And to make it more confusing, but hopefully also get to a point of clarity here, one thing you have to understand is that certain rights and principles under the original law remain unaffected and in effect by or after the reforms. So you have various rights and principles I'm going to summarize here today that were established in the original law and still remain part of the law going forward. However, you have certain rights and principles under the original law that have been fundamentally changed. So what are no-fault benefits?
Excuse me, Steve, before you continue,
Yes.
We're not seeing your PowerPoint. Is it supposed to be on the screen?
No.
Oh. My bad.
Okay, now I can see your PowerPoint. I mean, your.
Yep.
I just didn't want you to continue with.
I appreciate that.
There we go.
Yeah, there we go.
Okay,
So we had,
much.
yeah, I'm so sorry for, I thought I had all this covered, but I just did make a one change on that transition thing, and then I got a little off kilter here with the screen sharing.
Okay.
So here we go. This is where I was at. So what are no-fault benefits? So no-fault benefits consist of 3 different benefits if you survive a crash. There's the allowable expense benefit, which is the medical and care benefit. There's work loss benefits, which are an income loss benefits that cover the first 3 years of your income loss, 85% of your gross income, or up to a statutory monthly max, which is about $5,700 now. And then there's replacement service benefits, which covers household services you may need if you're injured. Those are covered up to 3 years and capped at $20 a day. And in the event that there is a death, there is the survivor's loss benefit, which is economic contributions that the decedent was bringing to the household that the dependents of the household can now claim for up to 3 years following the death. So one key piece of information to understand is that the 2019 reforms only change the amount of coverage available for allowable expense benefits, that medical care benefit. The other 3 benefits remain unaffected by these reforms. So you have 4 benefits. 1 is only in play if there's a fatality. The other 3 are in play if it's an injury. And those benefits remain in effect. It's that the reforms change the lifetime nature of allowable expense benefit coverage for many people going forward. And I'll explain that further. One key thing to understand about no-fault benefits is that they are payable as the result of just an accident occurring. So as long as the injured person did not intentionally sustain their injury, fault does not matter. Hence, that's why we call them no-fault benefits. So if I inadvertently run the red light and I'm severely hurt, my insurance company still has to pay my no-fault benefits because it was an accident. Yes, I was at fault, but fault is not the standard. It's just whether there is an accidental bodily injury sustained. There are limited ways people can be disqualified. The reforms don't really change those. If you are an owner of a motor vehicle and you did not buy insurance, you as the owner can be disqualified, only you as the owner. If you're in a stolen vehicle, you can be disqualified. And there are a couple other ways you can be disqualified that we don't need to spend our time focusing on here. One thing the law does, though, is that it takes away the right for out-of-state residents to be entitled to any of these no-fault benefits. So that is one unique aspect of the law where, yes, these benefits remain intact, but there is an additional disqualification added to the law so that out-of-state residents are essentially not entitled to no-fault benefits, only if they satisfy a very limited set of circumstances. So effectively, your out-of-state family and relatives and friends that come in to see you, if they're in your car and are injured, all these things called no-fault benefits are something that they are not going to be entitled to under the reformed no-fault law. The thing about the original no-fault law, in the sense of it providing these allowable expense benefits and not having a monetary cap or a number of years that they were available, is that it basically served as comprehensive medical coverage for auto injuries here in Michigan. And the unique thing about Michigan's law was that it didn't have a monetary cap or a time cap. And so we were able to provide coverage for people who were seriously injured in an auto crash and who needed benefits for the rest of their life. And we're able to do that without involving the government. This is probably the most important sentence of the original Michigan no-fault law. And this is the sentence that defines allowable expense benefits. And I'm not just trying to quote law for you for no reason. This goes to show how broad of a benefit the allowable expense benefit really is. And it says that the auto insurers have to pay for all reasonable charges incurred for reasonably necessary products, services, and accommodations for an injured person's care, recovery, or rehabilitation. So when my clients ask me what's covered under no fault, I basically say anything that's reasonably necessary for your care, recovery, or rehabilitation. It's important to note this sentence remains the law, but now we have limitations in terms of monetary caps and ways that people can opt out of having this coverage that will apply to many people going forward. Further illustrating how broad of a benefit the allowable expense benefit is, it covers, because of that language, reasonably necessary. It covers hospitalizations, surgeries, inpatient care. It covers in-home nursing care and attendant care, rehabilitative therapies, medical transportation, medical mileage, housing and handicap accessible accommodations, case management services, guardian expenses. So when you're talking about, hey, what does no fault cover? There are those 4 benefits already summarized, but within this allowable expense benefit, what you have is coverage that goes well beyond traditional medical care and covers the care needs of people in all sorts of settings and in many different ways, really any way that they can show with medical evidence that it's reasonably necessary for their care, recovery, or rehabilitation. The other thing you all should know as consumers is that there is such a thing called coordinated no-fault coverage. And this was available under the original no-fault law. And if you buy coordinated no-fault coverage, what you're doing is buying coverage that requires you to have your health insurance company. If you have to have health insurance to buy coordinated coverage. So if you have health insurance and you coordinate, it means your health insurance company is going to pay first for your medical care, and then no fault will pay what is not covered under your health insurance. You cannot coordinate if you have government sponsored health coverage through Medicaid or Medicare. The laws of Medicaid and Medicare basically say you cannot coordinate and elevate them to be primary. So therefore, those of you who are on Medicare were never able to coordinate under the original law, and you still can't coordinate going forward. The trade-off for coordinated no-fault coverage is that it's supposed to cost less because it's a huge cost shift away from the auto insurer. So if I have my Blue Cross company pay for my front line medical care, which Blue Cross would, that means my auto insurer doesn't have to pay. And there is supposed to be a big premium discount. Without getting too much into the controversy, there's some evidence that maybe that discount wasn't what it was supposed to be over the years, but nonetheless, that's the idea. I'm going to come back to coordinated coverage as we move through this. Whose insurance company pays no-fault benefits? The general rule is that if you're in an auto accident, whether you're in your vehicle or in a friend's vehicle or walking down the street or on your bicycle, you are going to first turn to whatever auto insurance is in your household. You first turn to any policy in which you are a named insured. And if you're not a named insured in a policy, you would turn to any policy issued by any resident relative you live with or your spouse. The statute uses the term spouse or resident relative. So basically anyone you're related to and you live with, you would turn to their auto insurance company if you don't have your own. There are some exceptions to this rule that I don't want to get too bogged down in the weeds, but I just want you to know that there are certain ways you can be injured, such as on a motorcycle, where you actually turn to the motor vehicle involved in the crash and not your own auto insurance. Same thing if you're an employer-owned vehicle. If you're an employer-owned vehicle, you turn to your employer's insurance and not your own. So there are some exceptions, but this general rule as a consumer is you should know when you buy no-fault coverage and you're in a crash. And by the way, this follows you out of state, anywhere in America or Canada. And if you're in an auto accident, you're gonna turn to your policy to recover your no-fault benefits. No-fault reform did not change this general rule. But here's the new reality for no-fault medical coverage. Kind of going back to Anna's story and people like Anna who have been seriously hurt, and going back to what I said to start off, the impact on the body and the need for medical care that can arise from an auto accident can be so significant that you go through hundreds of thousands of dollars of coverage within weeks of a crash. And I've seen this happen to many clients. So the lifetime benefit was so helpful because people could go forward and plan around there being coverage for whatever they needed, not coverage up to a certain monetary limit. But the new reality of no-fault medical coverage for the state of Michigan is that when a person is injured, they're still under the general rule going to turn to their no-fault policy that they bought for themselves or that is in their household. But now under the law, what it allows people to do is buy these limited forms of policies. And so they're going to be subject to those caps and limits. So it is only in a situation, for the most part, where a person is in a household with lifetime no-fault coverage who continues to buy lifetime coverage, even though they can buy limited no-fault coverage. It's only in those situations where people are going to have the lifetime coverage. And I'll just pause here and just reflect on the fact that for the medical community, this is a huge deal because they were acquainted for 40 years that when they had an auto injury, as long as the person wasn't disqualified for those limited ways I summarized, that they had a patient that they could treat up to whatever that patient needed, and they would be a source of payment. And now it's certainly the case that a lot more people aren't going to have lifetime coverage. There is this other part of the law and part of the kind of public policy aspect of the law, where the law decided it was going to provide coverage for people who are not covered under their own policy, didn't have a policy in the household, but they were still going to get coverage. And there are many different rules that provided guidance in terms of where these people sought coverage. But the bottom line is that the reforms went into the details of the law and changed those rules. And now the new rule is if you don't have a policy in your household, you will still get no-fault benefits, but you'll get them through this entity known as the Assigned Claims Plan, which is this creature of statute, and it's a group of insurers, and your claim would be randomly assigned to one of these insurers, and you get your no-fault benefits through that insurer that is assigned your claim, but your benefits will be capped at $250,000. So under the old law, what you had was all these people who didn't have their own policies, say senior citizens who didn't need to buy auto insurance, living in their house, and if they walked on the street and were hit by a car, they would have lifetime coverage, and they would probably get it from the policy of that car. There could be certain specific rules that affect the outcome of what insurance company pays. But in the original law, that person, that senior citizen who didn't buy auto insurance because they weren't driving, would still get lifetime coverage. Now, for them, they will be entitled to no-fault benefits, but they'll be capped at $250,000. There's also this unfairness for motorcyclists and people injured in employer-owned vehicles. I don't need to spend a whole lot of time on it. I already touched on it before, but the old law said that, and this is still the law for these individuals, the motorcyclists and the employer-owned vehicle, that you turn to the policy of the vehicle that hits you if you're on a motorcycle, or your employer, the policy issued on the vehicle by your employer if you're an employer-owned vehicle. And what the legislature didn't do is change those rules so that people could get the benefit of their own insurance buying decisions. So for the motorcyclist that's hit by a car, if that motorcyclist buys lifetime coverage, they're not going to be able to access it. They're playing a game of Russian roulette out there with the motor vehicles that hit them. And if they're hit by a motor vehicle that has a $50,000 medical expense cap, they're going to be subject to that cap and not be able to access their lifetime. Same thing with people in employer-owned vehicles. If I have an employer-owned vehicle and I come home and I put my wife and my kids in the car and we go to dinner somewhere and we're hurt, the rule says we turn to the employer-provided, the insurance company on the employer-provided vehicle. And if that insurance company has a policy that was capped at a certain amount, we're subject to that cap. So it's not the case that everyone can just choose their own fate under the reforms. And that's what a lot of the legislators said, that when it comes down to it, this law allows everyone to make their own choice. That's not really true. So the bottom line, after going over all these details, in terms of your insurance buying decisions going forward, is that the safest option is for people to buy unlimited, uncoordinated, non-managed care, no-fault medical expense coverage. So I'm going to reiterate this at the end, but the idea is you don't buy the cap policies that I'm going to summarize. You don't coordinate. You don't go for the managed care option that I'm going to touch on a little bit later. And you basically buy the lifetime, uncoordinated, non-managed care, medical expense coverage, and that's what you tell your insurance agent. This will ensure that you have the best coverage for you and your family, and that your reasonable needs will be covered if you're ever injured in an auto accident. So So in this situation, under the old law, excuse me here. So in the situation where you have an at-fault driver under the old law, I mentioned generally that you had limited rights against the at-fault driver. And here are what those rights were. You were able to pursue non-economic loss, which is also known as your pain and suffering or loss of enjoyment and quality of life. So it's this lump sum of compensation to compensate you for the fact that life has your quality of life has been greatly diminished by your injuries. And so you can still pursue, or you were able to pursue that type of damage against the at-fault driver, but you were limited to pursuing that type of damage in cases, only in cases involving serious injuries. So there's this thing known as the threshold injury standard. And under the original law, a threshold injury was death, permanent serious disfigurement, or a serious impairment of body function. And so there's this test about whether your injury qualifies, and if it doesn't, you don't have a right to pursue pain and suffering damages. That principle still applies under the reforms. Also, under the original law, you were not able to recover these damages if you're more than 50% at fault. So if I was the person who ran the stop sign and I hit somebody who was speeding slightly, I would be more than 50% at fault. The other driver would be somewhat at fault, but I still would not have a pain and suffering claim against that driver. There's also this damage known as excess economic loss. Work loss is covered at 3 years. So if you have work loss beyond 3 years that's covered through your no-fault coverage, you can pursue that excess from the at-fault driver. That is a right that still applies under the reforms. But can an at-fault driver be held liable for an injured person's medical expenses? Under the original law, because injured people had lifetime no-fault medical coverage, at-fault drivers could not be sued for medical expenses. So that was one feature of the law that really actually resulted in a great consumer protection for people. I will make the point that it's not just whether you're an at-fault driver. If you're the vehicle owner and you lend your vehicle to somebody and they cause a crash, you can be held liable as the vehicle owner. And if you're a business, your employees use your vehicle and they cause a crash, the business can be held liable for the person's damages. So under the original law, everyone had the protection that, yes, they could be sued for those limited benefits I just covered, but they couldn't be sued for each other's lifetime medical needs. Under the reforms now, though, if an injured person has limited no-fault coverage, or if the person opts out from no-fault medical coverage, then the at-fault driver can be sued for the injured person's past, present, and future uncovered medical expenses. That is a huge change and a huge increase in what we can actually be held financially liable for through a lawsuit against us if we were ever to be in a crash and be somewhat at fault for it. Not to get too detailed here, but there's this concept of pure comparative negligence that is part of the medical expense claim going forward now. And you might ask yourself, what is pure comparative negligence? Under this doctrine, a driver can be held liable for medical expenses in proportion to any percentage of their fault that is greater than 0. So in my example here, say Bob is 90% at fault. Bob's the person who runs the stop sign. Wanda was speeding slightly. It's ultimately determined by a jury in a civil case that Wanda was 10% at fault. Say Bob has $5 million of future medical care needs because he's paralyzed in the crash. Wanda can be sued for 10% of that $5 million. It's not capped, or it's not governed by that 50% rule that applies to the pain and suffering claim. If you're more than 50% at fault in this situation, Bob could not sue Wanda for the pain and suffering, but he can sue Wanda because he'd be more than 50% at fault, but he can sue Wanda for the medical expense claim because pure comparative negligence applies now. So the bottom line regarding liability insurance under the 2019 reforms is that anyone who has a capped no-fault policy or opts out of no-fault medical expense coverage, they can sue the at-fault driver for any of their uncovered medical expenses. This could be a huge financial exposure for anyone who causes the crash. As I said, there's the derivative liability principle that applies to vehicle owners, so they're liable for the acts of anyone they lend their vehicle to, and employers if the at-fault driver is in the course of their employment. So what this means on the liability insurance side of things is that people and businesses will all now need to buy as much liability insurance as possible. I want to quickly cover, just in this one slide, other major changes under the reforms. And these are the things that don't maybe have as much of a direct effect on consumers. I certainly think they have an incidental effect, but they're bigger deals for other people than, medical providers and lawyers and things like that. But some of these things have more of a consumer impact. But nonetheless, I don't have the time to go over all the details of these other major changes, but I just want you to be aware of them as being part of the law. So the reforms, they implement this very draconian medical provider fee schedule that is going to greatly reduce the amount that medical providers are reimbursed for servicing auto injury patients, and especially providers in the post-acute side of things that provide ongoing therapies and rehab to people are greatly concerned about this medical fee schedule, and that is implemented in July of 2021. There's also a limitation on family-provided attendant care, so that attendant care benefit, or aspect of the allowable expense benefit that I was talking about before, you can still claim family-provided attendant care, which is the ability to get your family member paid for taking care of you as opposed to hiring a commercial nursing agency, but your family members are now capped at 56 hours a week. So if they wanted to provide coverage more than 56 hours a week, they couldn't get paid for it. The insurers can agree to pay beyond that, but they're the rule is 56 hours for family provided attendant care. There's also substantial government insurer controlled regulations over the payment of allowable expense benefits. Those new rules will be effective very soon. And there's a fraud authority to investigate and prosecute consumer fraud. Unfortunately, that fraud authority doesn't have much legs to it in terms of investigating the wrongdoing of insurance companies, which I don't believe that all insurance companies are bad. I see insurance companies do good things, but I also see insurance companies do bad things. And I lament the fact that the fraud authority doesn't go both ways. It's really more focused on people and not insurance companies. But the biggest change of these reforms is what I've been alluding to, that people can now buy this limitation on their medical expense coverage. And this just turns the world on its head as we knew it, in the sense that people won't have the lifetime coverage, and at-fault drivers can now be held liable for all uncovered medical expenses. And I've already covered the background principles and concepts that are necessary to really understand these options. And now what I want to do is go forward and summarize these options. But I just want to ask, are there any questions that I should be covering?
Steve, excuse me, there is one question that's been asked when you talked about non-resident versus in-state, and I'll just read you the question and see if, and let you go from there. The question is, what should out-of-state residents who spend 5.5 months a year here in Michigan do about the coverage for an auto accident in Michigan? Do they depend only on their auto insurance bought in their home state? What complications may arise if an out-of-state resident has an auto accident in Michigan?
Okay, that's a great question. When I present on this topic, there's so much to cover that I always have to kind of choose how much details I'm going to include in my slideshow about a given topic. I don't have a slide for out-of-state residents, but I'm more than happy to quickly summarize how this works. The disqualification that I alluded to says that if you're an out-of-state resident, you are not entitled to any of those no-fault benefits at all, any of those benefits, the medical expense, the work loss, anything called a no-fault benefit, you're not entitled to unless you are a person who owns a motor vehicle that is registered in Michigan and insured in Michigan. So with regard to whatever are the circumstances of this person who might be living in Michigan for 5.5 months out of the year, when it comes down to it, the only way that person can become entitled to no-fault benefits is by owning a motor vehicle that is actually registered here in Michigan and insured here. And in doing that, they only make sure that they, as the owner of the vehicle, will be entitled to no-fault benefits. If, say, I was the out-of-state resident and I owned the vehicle and I insured it here in Michigan, registered it here in Michigan, and then came into Michigan with my family and my wife and kids were in the car and we're in a crash, I'd be the only one who'd be entitled to no-fault benefits and they wouldn't be. The only recourse for these people is to sue the at-fault driver, and they can actually sue the at-fault driver for all of their medical expenses, but only if they sustain a serious injury. So the long and short of it, and I'd be more than happy to talk to people more about the details of what this really means for making sure your out-of-state family and friends who come visit you, how they're going to be covered if they're in an auto accident. But the bottom line is that these reforms really put these people between a rock and a hard place. And it really takes away very important rights that I always was assured to have, I was always assured to know that I have for purposes of family and friends that come visit me out of state. So the best advice I can give you is that if you're somebody who's actually coming in Michigan frequently and driving here, you should own a vehicle that's registered and insured here, and that's the only way you're going to be able to tap into the no-fault system. Okay, I'm going to move on here. Excuse me here. Okay, so here This is an overview of all the options that are available, and I'm going to summarize them. But in getting to the world of PIP choice, as we call it, and by saying PIP choice, I mean the type of policy that limits your allowable expense benefit coverage. There are basic rules that apply to any of the levels of caps, whether you're talking about the $50,000 level, the $250,000 level, or the $500,000 level. So here are a couple of the rules. They only apply to the medical expense benefit, the allowable expense benefit that I've summarized. They don't limit work loss or replacement services or survivor's loss. It's a per individual cap. So if you have a family of 4 that has a cap policy and they're all insured, they all get their medical expenses up to that cap amount. It's not an aggregate cap. If you have a household that has 2 different policies and one policy has a higher cap, that's the amount that the injured person gets to have for their coverage. They don't get to stack the 2 policies. So if there's a $50,000 medical expense cap policy in the house and a $250,000 medical expense cap policy in the house, they get the $250. They don't get $300. You all are going to be presented with a form when you buy insurance going forward. And on that note, I should emphasize this, that your insurance buying decisions will be, you will be facing these new decisions when you go to renew your auto insurance. If you just renewed your auto insurance within the last month or 2, you're not going to have to deal with the new insurance buying process until you renew again. But I do recommend that you contact your agent to make sure that your coverages are what you thought they were when you renewed. But I'm just saying that technically, you probably aren't going to see all the paperwork from your insurance company until it's a renewal time going forward. And if I didn't emphasize this, all these options that I'm talking about are able to be sold as of July 1st. So in about a week from now, these options will be available. So if you've renewed before now, you won't have to deal with this for a few more months, but then you will. And when you do, you will be presented with a form that summarizes all these options, and it's very complicated. And I have some snippets of the form in this presentation to share with you. This is one piece of information, though, I want to get out there in terms of basic rules that apply to PIP choice and opt-outs. The rate reduction issue. First of all, the reforms do not guarantee that the total cost of a person's policy will go down. It only guarantees that for those who choose these limited options, that the amount they pay for no-fault insurance will go down. And this is just one line item on your insurance declaration page. So it's not that the total cost of your insurance is going to go down necessarily. It's that you're supposed to, if you buy one of these cap policies, get somewhat of a discount on what you're paying for your no-fault insurance premiums. And the other thing about these reforms that certainly bothers me is that if they're going to give a rate reduction, that reduction should be clear in terms of how it's calculated. As a piece of consumer information, you should know that the rate reduction in the law is defined as as a percentage that is supposed to be based on the average reduction per vehicle for the premium rates for PIP insurance that were in effect for the insurance company on May 1st, 2019, not the consumer. So the consumer that looks at his or her deck sheet and sees that, okay, I was paying $1,000 for no fault on May 1st, 2019. Now I'm buying this limited option and it says this is supposed to bring down my no fault by 35%. It's not going to be 35% of 1,000 necessarily. It's much more ambiguous as to what this rate reduction really is going to amount to for consumers. To illustrate what I'm saying, you can see this is a little snippet of a declaration page. For those who know their insurance declaration page would be familiar with how this is all set up, but you have line items of coverage, and where it says personal injury protection, that's the cost of, on this particular policy, the cost of no-fault insurance. And what I'm saying is that the law says that that amount, if you buy a cap policy, is supposed to go down by a certain percentage. And that's the only thing that is guaranteed under these reforms. I should state for the record that the law does say the lifetime benefit should be reduced by 10% of the average cost of the insurer on May 1st, 2019. So I guess if you stick with lifetime, you're supposed to get some marginal reduction, but I don't think that's going to amount to much. I mean, if you just took 10% here, that'd be $16 at most. And it's probably going to be less than that. So you now have a lay of the land in terms of there being all these options out there for people to buy. And you might be thinking, hey, he talked about coordinated no-fault coverage where you elevate health insurance to pay first. Where does that stand? Well, no-fault insurers can still sell coordinated coverage. So you have to understand, you could be able to buy a coordinated PIP choice plan that would effectively be the source of money that you would turn to for anything that's not covered by health insurance. If a consumer was thinking about buying a PIP choice plan who has health insurance, I would highly recommend you coordinate your PIP choice plan so you have that pool of money. If you uncoordinate and you make your no-fault carrier be primary, your health insurer that would have paid for your auto accident might say, well, your no-fault carrier's got to pay for it. And then all of a sudden, your no-fault carrier pays for what your health insurance company would have paid on the front lines of your medical care. So maybe it's a little technical, but my point here is the ultimate recommendation is to buy lifetime and uncoordinate. But if you're gonna go into PIP choice land and buy a less than lifetime policy, don't go uncoordinated because you don't want to blow through that money any sooner than you have to. And I fear that agents aren't going to really give people the right advice here. But this is certainly still part of the insurance buying decision process you all have to go through. To summarize the caps real quick, the $50,000 cap I've been alluding to is only available to a person covered under Medicaid, and if the person can show that their spouse and all their resident relatives have Medicaid or other health insurance or no-fault insurance that would cover them if they were in an auto accident. So they have to meet both parts here. They have to show they're on Medicaid and they have a household where everyone else has got coverage. This is a snippet of the form I've been talking to you about. The form is like 6 pages long, but this is just the snippet that talks about the $50,000 option. This is where it uses the concept of qualified health coverage, which is coverage that health insurance coverage that covers an auto accident. The $250,000 cap option is available to any person. If you're anyone out there, you can buy this. And again, the cap applies to you and your family members. That's the same for the $50,000. Any of these caps apply for you and anyone living with you. And anybody who buys these limited policies, just to reinforce the concept, if they have uncovered medical, they can sue the at-fault driver. So one way of looking at this is that you might see, hey, I'm going to buy lifetime. I know what I'm going to do for myself. But the other reality that's emerging here is that all the other drivers out there are going to have to go through all these options and decide which one they want. And I'm sure a lot of them aren't going to buy lifetime, which means more and more people are going to have uncovered medical expenses that they're suing each other for. $500,000 cap is the same as a $250,000 cap in the sense that it's available to anyone. And yes, you can sue for your uncovered medical expenses against the at-fault driver. Here's a copy of the snippet from the form. The lifetime option is still available. Interestingly, for those who buy lifetime, if they're hit by a drunk driver, they can't sue the drunk driver for their medical expenses because they did the responsible thing and bought themselves lifetime coverage. That's just part of the law. Everyone's got to go through this selection of option form on that long form I've been referring to, where you have to sign off that you want one or the other, and you have to initial it. And so everyone's going to have to be signing off on forms.
Oh my.
The other thing that's available, and I just talked to an agent about this, and I don't want to throw too much stuff at you, but there's this thing called an attendant care rider. And what it is additional coverage for family provided attendant care subject to those limitations I talked about, those 56 hours a week. But it's additional money over and above the medical expense coverage you bought. So if you bought the $250,000 of medical expense coverage and you were seriously injured, and you went through all that in your hospitalization and you came home and you had the attendant care rider, apparently that's a supplemental pool of money you have to pay for your care, your attendant care at home. I don't know the details of how that's going to be sold, but it's an option. So there is a question I saw about the opt-outs. So one thing that the politicians said in the media as they debated this for about a week before they signed into law with nobody reading it. And by the way, I just want to say, I probably should have emphasized that early on. I was very much involved with everything that really happened here in terms of these reforms. I shouldn't say everything, but all parts of the process in terms of talking to people in the Senate, talking to people in the House, testifying in front of both committees, dealing with the issue day in, day out. And what happened was they rushed these reforms through in both the House and the Senate. And then there was this debate that went on in the media for about a week. And then on a special session on the Friday before Memorial Day, they come out with a bill that's about 120 pages, and they roll it out. And I was there at the Capitol when this bill was pushed off a cart on the elevator there, and nobody had time to read it. And then they were voting on it within 45 minutes. So there's a lot to this law that I know that the legislators who voted on it didn't really even understand. So when you ask yourself why certain things were allowed to happen, my answer to you is perhaps there wasn't enough debate and scrutiny, and that's why it was allowed to happen. But in any event, there are these opt-outs, and these opt-outs are really concerning to me. And in that debate that I was referring to that went on between the political leaders and the media, at one point, I think it was the governor who said PIP choice is an option, but it can't be a zero. There can't be a zero option. And the reality is that there is a zero option. It's in these opt-outs. And this is how the first zero option works. If a person has health insurance coverage that covers auto injuries, they can go into their auto insurance agent, show that they have that coverage, and then opt out completely of medical expense coverage altogether. And that opt out applies to them and their family members who would be covered under that health insurance plan. So if I have a Blue Cross plan, does not have an auto exclusion, would cover auto, I can go in and buy a no-fault policy that has no medical expense coverage for me or my family if we're ever injured. And you might ask yourself, well, why is that a problem? First of all, health insurance does not cover everything that's reasonably necessary for someone's injuries. There are all kinds of ways in which health insurance has limitations in terms of how many therapies you can receive in a given year. You got copays, you got deductibles. There are certain types of therapies that people need if they're seriously injured that just aren't covered under health insurance. So health insurance is not the kind of coverage that allowable expenses, that allowable expense benefit coverage is. And then what happens to an excluder if they're injured and then they lose their health insurance? So somebody is seriously injured, they had health insurance to their employer, and then they lose their job because they can't go back to work and they lose their health insurance. They won't have any no-fault insurance to turn to, and they might not qualify for Medicaid because their financial assets don't qualify them, or they have too much in terms of financial assets to qualify for Medicaid. And then with regard to Medicare, they might not qualify because they're not disabled, they're not a senior citizen. So there's a very serious issue here for excluders if they're ever seriously injured and they lost their health insurance, that they really would not have coverage. The other thing about these people who opt out is that they can sue all of us for the first dollar of their medical care. So if you have the misfortune of having a mistake and you hurt somebody and they're an opt-outer, they can sue you for the ambulance bill, for the hospital bill, and for every single medical expenses related to their injuries. That's another feature of these opt-outs. People in Medicare have the same opt-out capability. If they are on Medicare and they have people in the household that have qualified health coverage, that would cover auto accident injuries, they can opt out of no fault entirely. And I have represented many senior citizens who have greatly benefited from the no fault system. And it's just a fact of our bodies that if we're older, traumatic injuries are typically harder to recover from, and they combine with and exacerbate pre-existing conditions. And I've seen senior citizens sustain brain injuries and then need to have ongoing care, and the no-fault system is a huge benefit to them and their families in dealing with all that. What this law allows senior citizens to do is just go without no-fault coverage at all, and then they're just to rely on Medicare and what Medicare covers. And here's a little chart. It's hard to digest it all, but the bottom line point of this chart is that there's a whole bunch of stuff that Medicare doesn't cover that auto no fault does. So I would never recommend to any senior citizen I know and care about, or just any senior citizen for that matter, to opt out. I think there's way too many benefits available under the no fault system, and that by opting out, that's a real dangerous situation to put yourself in, and you could be in a situation where you might need things, but you don't have a way to pay for them, and then you're choosing between, you know, your financial needs and your medical needs, and that's not where you want to be as a, you know, seriously injured elderly person. There's also this ability to buy a managed care plan. I don't need to talk about this too much. I really find this to be objectionable. It basically is a situation where the law is now going to allow insurers to write their own policies that set forth rules regarding the monitoring and adjudication of an injured person's care, dictate who they treat with. So it's available to all no-fault insurers. They also have to offer a non-managed care plan. There's supposed to be a discounted premium for people who choose this. It has to be primary. It applies to everyone in the household. I can just say this: don't ever buy a managed care option. I mean, until they're rolled out and it can be scrutinized and really determined to be consumer friendly. Otherwise, based on what I've seen in insurance policies, you really wouldn't want to mess with these, because there can be so many rules and technical details baked into that policy that could really be a problem for you if you're ever seriously injured. So insurers can sell this. It can save you money if you buy it, but I do not think it's in your best interest. So to summarize here, going back to 2 slides I had before, the bottom line regarding no-fault PIP choice buying decisions is that the safest option is for people to buy unlimited, uncoordinated, non-managed care, no-fault medical expense coverage that will ensure you have what you reasonably need. And that with tort liability now being changed, you all need to increase your liability insurance premiums as much as possible, because you can't guarantee you won't make a mistake and hurt somebody, and you don't know what type of insurance those people are going to buy, and their insurance buying decisions affect how much you can be sued for. And the last thing you want, especially if you have a decent amount of assets and you're later on in your life, especially, and you're trying to find that financial stability, is to have the worry that you're going to have a lawsuit brought against you and you don't have enough insurance coverage to satisfy the person and resolve their claim. Last point, uninsured, underinsured motorist coverage. This is coverage you buy yourself through your own insurance company that applies in the event you are hit by an at-fault driver who doesn't have insurance or doesn't have enough insurance. This coverage is optional. You don't have to buy it. We recommend that everyone buy as much as possible. This was the recommendation I would make even before the reforms. Nothing's really changed here. You can't guarantee whether if you ever hit by somebody, whether they're going to have insurance or enough insurance to cover your damages. And so the way you do guarantee that you have at least some amount of money available to recover is by buying this through your own insurance company. They stand in the shoes of the at-fault driver and pay you as if it was coming from the at-fault driver. So definitely talk to your agent about that. I do apologize for some of the transitional issues on my slideshow. I'm more than happy to pull up my question box here and see what we got. I'm gonna stop the screen share.
Okay, before you do that, Steve, I'm going to interrupt you for a moment. Thank you so much. It's been very interesting. We do have several questions, and I think that you can probably see the same questions. But before we do that, I'd like to put up our survey real quickly that lets our members decide regarding times of these meetings. So Donna, if you could put that survey up, we'll do that right now and then continue on. So
Should be up.
Yep, so if you would please just click on which one works for you, and we'll give you a couple seconds to do that. And then we'll go back to Steve and see what we can do in the next 10 minutes or so as far as answering questions.
And you can click as many as work. It's not just one.
Okay.
So one question is, why did the CCA costs go down already? Are they projecting the medical cost savings in advance or what? It's a very good question. The CCA is the Catastrophic Claims Association, also known as the MCCA, which is the Michigan Catastrophic Claims Association. In order to answer this question, I have to give a couple background points. The MCCA has been around since the no-fault law was enacted, and what it is a reinsurance fund. And the way it basically works right now, based on the monetary amounts that apply, if I was seriously injured in a crash, my insurance company has to pay for the first, I think it's $550,000. It changes every year, but just say it's $550,000. And then after that, my insurance company continues to pay for my lifetime medical, because I have lifetime coverage, but they get reimbursed for any amount over and above $5,500. They get reimbursed through the MCCA. The MCCA gets its money from all of us in a line item that's on your deck sheet for your MCCA assessment fee. That fee has changed many times throughout the years. And here are the basic points I just want to summarize to try to answer the question. There's a lot of controversy about how that fee is assessed and how the MCCA runs its operation. And there was actually a lawsuit that sought information from them about how they determine their rates. And they fought that all the way to the Supreme Court. And actually there was a loophole in the Freedom of Information Act that allowed them to not disclose their information. So there's a lot of ambiguity about why the MCCA charges what it charges. And actually going forward, we all could still be forced to pay money into the MCCA, even if we don't buy the lifetime coverage. That's part of the law. You could actually have an assessment fee, even though you are not going to have the right, if you buy limited coverage, to tap into that lifetime coverage that the MCCA funds. So there's that part to it. And the other part to it is that the MCCA has about $20 billion. And there's a concern that once they service all the people in the system, that the surplus isn't going to go back to the consumers. It could go to the insurers. And so there's a whole lot to talk about there. You shouldn't expect your MCCA assessment fee to go away entirely. What it'll be will be a great unknown, or it is a great unknown at this point. The other question is, the insurance industry is characterizing what you are referencing as opt-out as a waiver. Check the box to waive X coverage. Explain this, please. Well, whether you call it an opt-out or a waiver, the bottom line is if you choose that $250,000 excluder option I was summarizing, or the Medicaid opt-out or waiver, you are choosing an option that leaves you with no medical expense coverage through the no-fault system. So I would just say, don't choose that. Another question is, Detroit mayor is now saying he wants some amendments. What is he wanting? You know, the mayor has been quite involved with this whole thing, and what he wants and why he wants it is anyone's guess. He's been the political figure that has pushed this more than any other political figure in Michigan. And I don't quite understand why he's doing what he's doing. And I'll just leave it at that. Remind us why uncoordinated is better than coordinated, say for some with Medicare and Blue Cross Blue Shield. Okay, first of all, if you're on Medicare, you can't coordinate. And that's just the federal law that says you can't elevate Medicare to pay primary. So if you're on Medicare, you can't coordinate. So the decision's made for you. Why uncoordinated is better if you have lifetime coverage is that you don't have to serve two different masters. I have clients that have the lifetime coverage, or all my clients at this point do. Going forward, there are many that are not going to. But the clients that have the lifetime coverage and to coordinate have more hoops to jump through. They have to show that health insurance received the bill that doesn't cover it, and then you have to pass it on to auto insurance. And you have to prove that you've satisfied all the rules and obligations of their health insurance before no fault will pay for it. So I just don't like that people serve two different masters. It's a much easier path from point A to point B if you're uncoordinated. There are other technical reasons too to stay away from it if you can. But going back to my other point, if you go to that PIP choice option and you can coordinate, you should, because that's a limited amount of funds that you have available under the no-fault system, and you should delay needing to use them as long as possible and rely on health insurance as long as possible.
I think that
And-
covers them all, Steve. Oh, go ahead. Did you
No, I'm
see
sorry. There's one. The question is, if I have LTC insurance, do I really need unlimited medical coverage? Well, there is that perspective that if you think your other coverages that you bought for yourself really cover you, perhaps you can make an argument that you don't really need it. But I don't think there's any long-term care insurance that provides coverage under that standard of reasonably necessary that I summarized today. And I think that that is something that is definitely a good thing to have if you're ever seriously injured in a crash.
Wonderful. Well, thank you so much, Steve. We really appreciate you being here. To those folks who have, several people have asked about where they can get your information, but we have been taping our webinar, and this will be available online, so we can go back and see that. And I'm assuming you also will take calls at your office, Steve. Is that correct?
I will, and I just typed my email address into the chat box.
I got it.
So,
okay.
So I know it's a lot to take in, and hopefully it gave you the lay of the land about what this new complicated system's all about. But I'm happy to talk with you all if you email me or give me a call.
Wonderful. Well, thanks again, Steve. We really appreciate it. Thank you to Donna Mullins and Anna Scott for helping with this meeting. And we are hoping to do this once a month to replace our luncheon meetings. And we hope that those of you who joined us enjoyed your lunch and had great service at your restaurant. So take care and watch your email for the links that will give you things. Yes, Steve?
I just note on the slide there where there's a V in my email, Dravis, it should be Dramis. I just didn't want people to email me the wrong.
Good catch, Steve.
No problem. Yep.
Very
All right.
good.
Thanks so much, everybody.
Thank you very much. Yep. Take care. Bye-bye.
All right. Thanks.
Okay. And I will shut it off.